Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Dissolution by court order. The court may make an order for dissolution of the partnership firm on following grounds. Insanity, on insanity of a partner. If a partner becomes incapable of performing his duties as a partner due to unsound mind, and the application of dissolution on this ground has been made by the next friend of the insane partner or any other partner of the firm, the court can dissolve the firm. Permanent incapacity. On permanent incapacity of a partner. If a partner other than a sleeping partner becomes permanently incapable of performing his duties as a partner due to illness, mental or physical disablement of any kind, the court can dissolve the firm upon suit filed by other partners for dissolution of firm. Misconduct. On partners' gross misconduct prejudicially affecting the business, where a partner is guilty of misconduct which, having regard to the nature of business, is likely to affect prejudicially the carrying on of the business and business prospects of the firm, the court can dissolve the firm on filing a suit for dissolution by any other partner of the firm. Other grounds of misconduct. The court can dissolve a firm on some other grounds of misconduct like gambling, fraud, taking away books of accounts, etc. Example: A and B were partners in a business. B was convicted of travelling on a railway ticket without and with an intent to defraud. Held as the conviction was for dishonesty, it was calculated to be detrimental to the partnership business, and it was a sufficient ground for compulsory dissolution of the firm. Persistent breach of agreements, where a partner willfully or persistently commits breach of agreements relating to the management of the affairs of the firm or the conduct of its business, the court can dissolve the firm at the suit filed by any of the other partners. Impossibility to work together, where the conduct of some partner is such that it becomes impossible to carry on the business in partnership with him for the other partners, the court may dissolve the firm on the suit filed by any other partner. Example: A and B are partners in a firm. A has an adulterous relationship with B's wife. This is a sufficient ground for compulsory dissolution of the firm. The conduct of A, though not committed in the actual business, is likely to affect prejudicially the carrying of the business so far as A and B are concerned, because this destroys mutual confidence. Transfer of interest. On transferring interest in partnership to third party, where a partner has transferred the whole of his interest in the firm to a third party, or has allowed his share of interest in the firm to be charged, or has allowed his share of interest in the firm to be sold for recovery of dues, the court may dissolve the firm at the instance of any other partner. Perpetual losses. If the business of the firm cannot be carried on except at a loss, the court may dissolve the firm at the suit filed by a partner. Just and equitable ground. The court can dissolve a firm on the ground that it is just and equitable in the circumstances of the case of dissolution of a firm. This clause empowers the court with a very wide discretionary power to order dissolution if it appears to the court that the dissolution of the firm is desirable in the present circumstances. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.